Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Welcome to the podcast. My name is Steve Weissman. I'm a lecturer at the Goldman School of Public Policy at UC Berkeley and the former founder and director of the Energy Program at Berkeley Law. Our reason for getting together today is to have a conversation with our guest, Steve Ferry, who's the author of a brand new book entitled Powering the Future, A Lawyer's Guide to Clean Energy. I have a little bit more to say about Steve in a couple of minutes, but just to try to set the stage. You know the phrase, if you're a hammer, everything looks like a nail. For those of us who've been functioning in the energy law and policy world for some time, you start seeing the importance of energy popping up in almost every aspect of our society. It drives our energy use, drives the economy. Our energy choices can pollute the air or help to clean things up. Fossil fuels are the major contributing factor in warming the planet. Our energy decisions and strategies define our international alliances and drive and spark a lot of our international crises. And in terms of people within the United States itself, our energy choices wind up picking winners and losers. We have energy deserts. We have places where there's more of an impact from the use of fossil fuels than in other locations, and those areas tend to be places which are located in otherwise disadvantaged communities. So a lot of challenges to look at, and sometimes it seems to me almost surprising that we don't insist that everybody at every level of our educational system really spend time focusing on these energy questions. They're so fundamental to everything in our lives. Steve Ferry's been looking at these challenges for quite some time. He's a professor at Suffolk University School of Law. He's author of many different books and a tremendous number of scholarly articles as well related to this field, and he's been a voice in energy law and policy for quite some time. He also has done a lot of work internationally and domestically, working with the development of various energy projects, and has often testified before both houses of Congress. Steve, it's great to have an opportunity to talk to you about your work up until now and about this new book. As I just mentioned, you've written a lot of books and other publications. So why this new book and why now?
Well, Steve, good question, and good to see you again today. Well, for several reasons, I think. One is, as you've indicated a minute ago, energy is one of the most regulated things in our economy. Things are changing now. As many as 1/3 of the states have somewhat deregulated their control over this, and that changes things, but it changes them differently in each state. And what also has changed is it's not only utilities that are building and managing new energy sources, particularly new electricity. There are a number of non-regulated, entrepreneurial, sometimes called merchant power projects going forward. Secondly, there's a huge amount of new case law. So just everybody, I think, has heard about the decision in 2022 in West Virginia versus EPA, unveiling a new major questions doctrine, and it's a decision that applies to the electricity sector here. There are another 4 decisions just at the end of the 2024 session of the Supreme Court, perhaps not quite as visible, that have changed things a lot. So we've lost the Chevron doctrine vis-a-vis the Loper-Bright case. That has changed in the Supreme Court decision. That was the most cited decision in the last 40 years. Cited more than 70 times by the Supreme Court, more than 18,000 times by other federal courts. That changes deference to the federal branch of government. We have the Corner Post decision, also in mid-2024, that is going to erase a statute of limitations when you can challenge agency regulations. We also then have the Jarkizi case, which limits the ability of federal government to assess fines. So that's going to limit, in theory, EPA's ability to issue fines for different sorts of environmental energy-related things because they don't have juries at EPA. And there's also the Ohio versus EPA case, which allows the Supreme Court to enjoin approximately half the states from imposing federal authority on states. And finally, I guess the last reason for this book and now is that most people assume, well, with all these court cases, cutting back federal jurisdiction, so isn't there a vertical switch to more state power? And the answer is maybe. Yes, in one sense, and no in another sense. So people often look and say, well, 28 states do their own siting of new electric generation, and therefore there's no local level, right? It's 28 states are active in this. The book spends some time going through each of those 28 states, statute by statute, citation by citation, indicating by the time that you look out that some of them do not regulate non-utility projects. Some of them have minimum sizes that do not accommodate the somewhat smaller renewable solar and wind power. And some of them also require that they comply with local zoning. The 28 states that actually regulate effectively the new renewable power that seems to be the dominant form of power now is cut back from 28 states to 4 states. So this book tends to map each state where there are opportunities, where there are barriers, and some workarounds with actually physically maps and lists of ways to get to the citations. I guess the last thing I would say is this really calls for multidisciplinary skills. We used to have separate environmental, energy, land use, and climate change practices. Now, recently, there obviously are new energy interpretations that I just mentioned. Environmentally, the National Environmental Policy Act was scaled back and changed in 2023 as part of the Debt Reduction Act. Land use is more important now because as we switch to solar, wind, and other renewable sources, they use significantly more land because they are a less dense form of power. So that means more land use, more local control of land use. And so all these different disciplines seem to be in play at once.
Well, you mentioned a few important areas where laws in other spheres tend to be implicated when we're talking about energy. But really, in some ways, isn't it true that energy impacts and is impacted by almost every aspect of our legal framework?
Yeah, that's really true what you say. And I think that's an important point you've just raised. So everywhere you look, I think that's reinforced. So, for example, we have a Department of Homeland Security that we think of as involved in other things. The Department of Homeland Security identifies 16 significant sectors of the U.S. economy that they're trying to protect and secure. All 16 of those require reliable electricity to operate and use. There was a survey in the Atlantic Monthly about what were the most important inventions of all time. They initially conceded, without doing their expert poll, that the wheel got first place. That was sort of set aside as without wheels, where would we be? And I think that's effective. Electricity, place number 3, was behind the movable type printing press. Well, if you look at our future now, I think we're not using movable type printing presses as much as we're using electronic media. And so electricity is at least third, if not second in that list. And again, it's the most heavily regulated thing in this country. In foreign countries that I've worked in, it's always heavily regulated. It's considered essential, and it's essential for in ways that we actually now distinguish between developed and developing countries, depending on whether they have reliable and long-term electricity. And now there's a major move the United States is part of to make it sustainable or more renewable.
Yeah, a lot of people talk about this concept of there being a energy trilemma. The people talk about the fact that we really have at least 3 major areas that we're concerned about when we think about energy use. One is security, just trying to make sure that we can keep ourselves safe, both strategically and just in terms of health and temperature and all those other things. And we care a whole lot about, at the same time, about access and affordability. You're mentioning, that in fact, at this point, we still have, I believe, in excess of 1 billion people without access to electricity around the world. And it means there's a tremendous amount of interest in other countries in building up their ability to provide electricity. But at the same time, we're concerned very much about sustainability. And And that really means not only traditional pollutants, it means also very much trying to deal with climate change. And so how do you think all this fits together in terms of trying to understand how we look at law in the United States and policy in the United States going forward in terms of making our better energy choices?
Yeah, a good point. Well, yeah, the sustainability issue is really fascinating to me. Let me just give you, you mentioned international, I'll give you a quick example here. If we take some of the islands that supposedly are going fast underwater because of rising sea level in the South Pacific, Solomon Islands and some places like that, they are paying about 4 times as much for electricity as we do here in the United States. So it appears to be a bargain. And over there, it's clearly more cost effective to do renewables, which are less expensive now. Solar and wind are showing themselves to be less expensive in the United States, even at lower prices for power here than the more traditional fossil fuel measures and nuclear measures. But over there, for example, there is extreme resistance still among the utilities not wanting to stop importing diesel fuel and at 4 times the cost of here producing power. So there's a reluctance, I think, in the system. I think systems move slowly. And of course, the issues on climate are issues where we're trying to move very quickly by, we have deadlines by 2025, internationally by 2030. As a world economy, we're way behind on all of those deadlines, and it's going into question what we will do. Access is important, though, because one of the things here in the United States is that electricity prices in general have tended to go up a bit. Some of that is because a number of the states are subsidizing some of this renewable transition, which long-term is good, but has some short-term price effects. So it's a mixed bag out there. But it's also interesting, too, that the Biden administration's extension of various tax programs so that they did not expire now give a premium discount if you are serving low-income communities or locating things in distressed communities. So there seems to be a certain equitable factor that also has come in here in some recent policy.
Do you think that there are ways in which the path we take in the United States in terms of developing renewables and moving off of fossil fuel can have an impact on some of these other countries you're talking about?
Well, yeah, the United States is looked at as a leader. And when I started doing some international advising on some of these similar issues a while back, the issue was always that you had to subsidize the renewables. So to convince a country in Asia or a country in Africa or a country in South America to go with solar and wind, it had to be subsidized by the World Bank, not only because of the utilities seemed to want to do it the way the U.S. utilities had done it with coal-fired power or diesel fuel, but also because they were more expensive. A major change has occurred in that, as we mentioned, solar and wind are really now deemed to be cost-effective. Natural gas is our low-cost fossil fuel source of electricity. And even in the next few years here, it is expected that wind and solar will be less expensive than natural gas. And we enjoy, with all of the fracking that has occurred, we're now exporting natural gas instead of importing liquefied natural gas. And natural gas is relatively cheap among all the fuels. So that's quite a change here, I think. So all these things are changing a bit on the screen here, I think, in terms of really the economics as well as technology implementation and getting experience with renewables are changing what is sort of the most cost-effective grab bag of options. And there is an interesting case even going back between before the 2024 and 2022 Supreme Court cases that have changed so much in the last 2 years. There even is a decision of the Supreme Court in 2015 in Michigan versus EPA, where the Chief Justice announced that even when you're making regulations at the federal level, you always have to consider cost. Even if the statute doesn't say you have to consider cost in order to be reasonable and appropriate. And I think the big advantage now is that, it's not just so much for environmental reasons, but also for cost reasons. The two vectors are really aligning where there's a different technology, but it has different challenges. As I said, in terms of land use, wind and solar power can use as much as 10 times as much land to produce the same amount of energy because it's a less dense form of energy, wind and solar, and also because it doesn't operate 24 hours of the day. Obviously, the sun and the wind come and go in different cycles. So there are, this is implicating more local control and local power. And oddly enough, there has been a large increase in also local opposition to certain large solar and wind projects. So there is some interesting new areas where environmental, energy, climate, and land use attorneys are going to find some new challenges and some new workarounds are needed.
Can you say a little more about the trade-offs between central station solar, the large facilities that in the West tend to be located out in the deserts, among other things, and what people refer to as distributed solar, which would be on the customer side of the meter, maybe on a rooftop or in other places on their property? Where are the trade-offs between those two?
Yeah, okay, so they're interesting trade-offs. One of the interesting, lots of trade-offs here, so I'll try to be concise, but one of the interesting things is we have always in the past, with the large fossil-fired projects, we have brought the fuel to someplace near the consumers. So we've moved coal or natural gas by pipeline or oil by pipeline or ship to something in the general vicinity of major urban areas and other areas that demand power. And we were able to stockpile that. You can stockpile coal, you can stockpile natural gas in a pipeline, you can put oil in tanks. And so we basically move the fuel to the people. The difference with renewables is to get the best renewables, you've got to go to where they are. So there are areas of the South, and particularly the Southwest, Southern California, Nevada, Arizona, New Mexico, Texas, et cetera, that are particularly good access for solar. And again, as you tend to go towards the equator, you get a better angle. Solar works best when you've got a 90-degree angle of the solar hitting the panels below. So the closer you are to the equator, more you get less variation over seasons. So there are certain places that are better, and wind power, it makes a huge difference where you go, because if you get 10% stronger wind, you are not just getting 10% more power, you're getting 10 cubed greater power. So you're getting 10 times 10 times 10. So going to the places where the wind is best, you're going to be much more cost effective. One of the interesting issues then is, since often those places are not near, and when you can site them are not near population centers, we need new transmission infrastructure to move the electricity more or less at the speed of light, give or take a little bit, to the population centers. And transmission lines are now tending to be for centralized power. Transmission lines are starting to be the thing that takes the longest, that may still require NEPA, National Environmental Policy Act, environmental impact statements. Those statements typically take 2 to 6 years and cost roughly $2 million when they have to be filed. They delay a lot of things. So it's not so much that we don't have the solar, the wind, the hydro, waste, or other renewable sources. It's the matter of being able to move it as we need to. And with solar and wind, because it's not always sunny in the same places, you need to be able to move that more ambitiously. So that has turned out to be the one of the issues. The other thing I will say is the interesting thing about solar is you can also put it on rooftops where people are, where people work. And in that case, you typically do not need new significant infrastructure. So maybe some of this is that we put more of it where people are on already roofed or surfaceable surfaces. But again, it's more expensive to do that typically, to put things in smaller amounts on roofs than it is with solar to go to a large field and put a lot of 20,000 panels in a field. So they're trade-offs economically.
We've been talking a lot so far about the supply side. Let's flip over to the other side for a minute, because things are changing there too. Right? We're having potentially dramatic changes in the demand for electricity. Where's that coming from?
Yeah, it's coming from a lot of sources. Let's talk about that. It's one is we've developed new technologies. So for example, artificial intelligence has tremendous potential that everybody's talking about, changing not only the practice of law in many ways, but changing how we do a lot of things, and gives advantages to countries that can use it effectively. That uses a lot of power. Second, cryptocurrency has become a big issue. People have probably heard something, if not invested in it at various on various TV stations and other things. Most of that used to be until 2021 located in China and a few of the former Soviet republics. China closed that out in 2021, and most of that has moved to the United States. Interestingly enough, the crypto miners are tending to prefer to be near older fossil-fired power plants that are near closing for their lack of economic viability, and they can demand enough 24/7 around the clock, massive amounts of power to have massive banks of computer trying to solve equations to mine cryptocurrency. But the other thing that's changing it too is there's a major push both at the federal and state level to substitute electricity for other services that use fossil fuels. So we've all heard about electric vehicles, electric EVs or electric vehicles, which supposedly we're going to be moving to significantly within the next 10 years, are going to substitute electricity for their fossil fuel, gasoline or diesel fuels. The other major push that is coming at this time, perhaps a little bit more from certain states, is there's a move to push buildings, whether they're our residences or our workplaces, off of natural gas and fuel oil as a direct combustion fuel into electric heating. Now, again, electric heating used to be about 3 times more expensive than fossil fuel because of our electric power plants wasting the majority of the fuel as waste heat where they produced it. Now, though, with electric heat pumps, electricity has become more efficient. So there's a new technology, a new equation there. But by the time that, just a quick ending statistic might be of interest to all, now about 17.5% of U.S. energy is electricity, so less than 20%. It's forecast that as we make these moves of the new demand, whether it's artificial intelligence, crypto mining, or other uses we have, along with electric vehicles, heating transitions, that 17.5% may go to somewhere between 40 to 50%, which can be at least doubling, maybe tripling the percentage of our economy that uses electric energy rather than fossil energy. So that's the demand side that it's kind of shifting. It's kind of shifting beneath our feet in ways that are changing the practice also of law.
Well, you're finding more and more instances where local governments and sometimes states are actually trying to insist on changes to the way energy is being demanded. I'm sitting here in the city of Berkeley where there was an effort to require that new buildings of a certain size going forward not have gas infrastructure, and that has been pushed aside by a couple of courts. I wonder if you could say a little more about that, because I know part of what's so challenging in the energy field is this interaction of federal, state, and local laws and interests and the way that preemption gets in the way often. So where do we stand on all of that?
Okay, good question also. And this is something that I think is a little bit below the radar screen, because we often assume, as most countries in the world do, but not all, that the federal government has significant control. I guess if we roll back to our revolutionary times, not that either you or I are quite that old yet, but if we went back to the Revolutionary War, at the end of that war, when we needed a constitution, the colonies, each a little bit different in terms of their beliefs and their organizational structure, were really stronger than what we had federally, which was really George Washington's army at that point. So the only power that the federal government actually got out of our Constitution is it got certain, commerce clause, taxing, war treaty, and control over federal land, a fairly limited bag of authority. Everything else by the 10th Amendment got reserved to the states. And the Supreme Court has certainly in terms of land use, going back to one of these disciplines we've been talking about, and to some degree environmental health and safety and environmental quality, that is reserved by the 10th Amendment to the states. And so there are a series of other recent decisions reinforcing this. Muir versus Wisconsin in 2017, if I recall correctly, reinforces you look at the local jurisdiction and state jurisdiction interpreting land use. Virginia uranium versus Virginia case in 2019, if I recall correctly, also defers to state control over these things. So the states have a lot of this control reserved to them over land use, over environment, et cetera. And as I said a few minutes ago, while we look and we can see out of 50 states, 28 of them have state-level siting authority for new power plants. When you really do the math and you look at how many of them don't apply to non-utility power plants, which are the new majority going forward for the last 10 or 15 years and following, and you look at sizes that they do and don't have authority up at the state level, only 4 of these 28 states, or only 4 out of the total 50 states, actually have effective state authority. So we're back to local authority in the state-federal split as to who has to approve this, and particularly with regard to transmission lines. Let me just say one more word about both state and federal power. In terms of citing new transmission lines, it is clear under the Federal Power Act and under a number of FERC orders that they've issued that they concede that states have to approve all interstate transmission lines. There are a number of states recently that have opposed transmission lines coming through their states to serve their adjacent states. So there's one case in the West. I'm happy to name the names of the states that won it. There are 3 or 4 recent cases on the East Coast. And in all but one case with the technicality that they waited too long to bring it before the court, the federal circuit courts have upheld the states having exclusive authority to deny transmission lines coming through their states if they're afraid that they'll be billed for them even though not benefiting from them or for any other reasons. So at least we're at that point. Now, there is an amendment in the Infrastructure Act of 2021 where there is a change to Section 216 of the Federal Power Act, supposedly going to give the federal government, FERC, only in highly designated, high-impact transmission need corridors designated by our Department of Energy, the ability to, after 1 year, if the state has not approved a line coming through that it doesn't want, a transmission line for electricity, to preempt that and issue eminent domain authority to take land. 2 problems with that, I suppose. One is this was tried in 2005 amendments, and both the, if I recall quickly, Ninth Circuit and Fourth Circuit ruled that this was not permissible. This version of that change in 2021 is a little bit stronger. So that is significant. And so that it's not been tested yet. The Department of Energy is still trying to designate 10 national corridors now, but we'll see whether that holds up or doesn't hold up. It didn't hold up before. The other issue is a gap in what was enacted in that Infrastructure Act. There were amendments that would have cured this. A coalition of both Democrats and Republicans would not agree to it. And so what we have is the eminent domain power that can be exercised by FERC under this new statute, assuming it's upheld, is only to take privately held land. They cannot take state-owned land, the way it was a gap that they left in the drafting. A lot of places you want to run these new interstate transmission lines are either going to be across rivers or along highways. So interstate highways are great places to run a line down the center divider. The land under interstate highways is largely state-owned land. So if a state wants to resist, it can resist that normal path. Secondly, if you take the 48 contiguous continental United States, 44 of the 48 have significant rivers or streams as part of their borders. And all the land on the shore and under those rivers and streams typically is mostly state-owned land rather than private land. So again, if a state's cooperative, no problem with this, but we've had a case already of a half dozen states, in large part successfully upheld by the courts, fighting new transmission lines for largely renewable power coming through their states that they're sort of saying, we're fine, we don't need this. The adjacent states are very, dense cities in the adjacent states need this. And just one more aside here that just, not to go on too long, but one more aside. California, of course, is our biggest state. It's the 5th largest economy in the world. It's critically important. It's been a leader in renewable power. There's a budget deficit that has occurred in California this year, and that has resulted in some of their support for renewable power having to be cut at the margin to try to get their balance in order. That means that California is going to look more to try to import perhaps renewable power from adjacent states like Nevada or Arizona or Oregon. California now imports twice as much power from the east through Arizona and Nevada than through the north in Oregon. And of course, unless California sites wind projects and lands them in their state, there are no states to the west or there's no siting to the west. Offshore wind would be the possibility there. And that is going to be interesting as to whether some of the adjacent states resist in some way the import of additional power through their states. As I say, the Ninth Circuit has upheld that in the past when additional interstate lines into California were successfully blocked by an adjacent state. So what I'm saying is the practice is becoming much more multidisciplinary. There are much more obstacles. Going back to your question, the federal, state, local split is more profound than I think it's normally assumed. And there's significant amount of power at various levels, various disciplines here. And so navigating all three of those levels at once in several disciplines of energy, environment, land use, et cetera, has become a little more of a challenge in some ways.
We had the Federal Power Act, which has been in place since the mid-1930s. And people like to talk about there being a bright red line that distinguishes state jurisdiction from federal jurisdiction. You touched on one of those areas where it generally was expected that transmission siting would occur in the states originally. But, we had the grid is one big machine, and the grids in the United States, other than the contiguous 48 states, other than Texas, you've got all the other lines are broken into two large interconnections that are multi-state. And so what I think federal regulators have learned over the years is as they try to become more and more effective, they realize that it's hard to stay within those boundaries, isn't it? To stay within the jurisdictional boundaries that people thought they were defining in the mid-1930s. And so, would you agree that FERC is becoming an agency with more pervasive regulation and maybe even greater power than it had before?
Yeah, I think that's an important point. And so when I actually did a survey back about the turn of the century, maybe just before the turn of the century, you looked at the amount of wholesale power sales where one utility sells to another non-end user, like to another utility or another vendor of power. It's not the retailer. Only 8%, that's 8%, right? Not 80. 8% was wholesale. Today, the last time I looked, we're in the mid 40%, and it's climbing every year. And that's partly because states have deregulated where power can be sold in roughly almost a third of the states by somebody other than the regulated utility monopoly. And those companies are moving power around wholesale and obtaining power. And so we're now almost at half of that. Every wholesale sale is regulated by FERC in Washington, D.C., and the retail sales are exclusively regulated by the state public utility commissions. So this very effort of some states to deregulate to get more competition, which is certainly a worthwhile objective, has really lessened state control in that sense. Now, that's state control over the terms and the pricing of the power sales. So, that switched to be more federal. However, the Federal Power Act, again, the Federal Power Act in 1935 is very different than the Natural Gas Act of 1938. Natural Gas Act gave FERC in D.C. Almost exclusive power over all the interstate pipelines and where they put them, et cetera. So that's much more federalized or much more centralized at the federal level. Federal Power Act was not as centralized, and there are a number of Supreme Court cases and actually in some FERC preambles to FERC regulations this year and a couple of years ago too. They say right at the start of their order, we're not changing any of this, and we recognize that states still permit electric transmission lines. So electricity, even though there's a federal interstate need now, as we're trying to make power more nationally movable in a sense, we're still confronting the existing statutes. And the local state PUCs, I think, enjoy the power they have. So the Association of Regulated Utility Commissioners, I think, is not anxious to cede the remaining power that they still have in this regard. And there's some court cases now just starting to emerge, again, with a state-federal tension over who is citing what kind of new infrastructure for the new electric economy we're moving towards, as you mentioned, with a lot more demand for power and a different kind of supply.
Well, and meanwhile, the federal regulators have been referring to FERC, the Federal Energy Regulatory Commission. It, a number of years ago, issued an Order 1000, that declared that all of the transmission owners within a particular region had to work collectively to develop a plan forward-looking plan for transmission development. And FERC has recently updated that process. Can you say a little bit more about that? I mean, here's FERC trying to find a way to make sure that these cross-border needs are met, and also try to deal economically with the most efficient way to deliver power, and they're reaching across state borders. How's that working?
So yeah, that's an interesting example there. So FERC jurisdiction largely is over the independent system operators and regional transmission organizations, which they have utilities as part of them in slightly more than half the states. So perhaps let's call it 60%, 60% of the states. So that's who's really affected by Order 1000. And Order 1000 is the last of several successive orders over the last 20 or 25 years that sort of beef up the federal role in trying to get these 60% of ISOs to plan more regionally, not just utility specific, but in a wider area transmission. In Order 1000, there are some comments in the side of that order that say we recognize that we are not changing any of the traditional authority of the states and confess that there still is state permission necessary to site lines. There's a new order that just came out in the last couple of months here in 2024 called Order 1920. And what is really interesting now is, FERC is a very interesting commission, and it's kind of a quasi-judiciary commission. It regulates transmission terms and pricing, although technically not construction. It regulates wholesale sales and interstate sales. But it also has an interesting requirement that not more than 3 of its 5 members can be from either political party. So they have staggered terms. So you get a mixture of different appointees and different presidential administrations. Just to digress for a half a second on that. So they basically said, we want more integrated planning. One of the commissioners, Commissioner Christie in that regard, dissented from, there were only 3 sitting commissioners at the time, so he was the one dissent among a 3 vote. He actually said, well, we're doing this in 2024. We've had the West Virginia versus EPA case that raises major questions doctrines anytime there's a major U-turn on a major issue. Electricity is the major technology in the United States. This is a bit of a change in policy. I see it more just as a continuum, but said it's a significant change in policy. And he said this is a major question doctrine. This is in a lot of trouble if this goes to court. Now, again, this new order is just a couple months old at this point. Then we got the Loper-Bright decision in June. So I think Order 1920 was in May of 2024. In June of 2024, we got Loper-Bright overturning Chevron. The same day, Commissioner Christie said that the last possible thread that this had of being suspended as being upheld has just vanished and been suspended. So interestingly enough, I think what makes legal practice even more complex now is oftentimes inside commissions, there are dissents that are actually raising legal issues as impediments, not even waiting until it gets challenged. So it's certainly gotten the brew has gotten richer, if nothing else. And so the interesting, and there already are some I won't take any more time today to go over some pending cases, but there are already some pending cases where the FERC ISOs are trying to pressure their plan to impliedly require the state to approve the transmission line. The state is refusing to cite the transmission line, and now we've got to fight again as to whether FERC can only plan or whether, even though there's no express preemption, somehow there's implied preemption at the federal level. And of course, the preambles to these FERC orders, as well as the Supreme Court decisions, have sort of said it's, as you said, a bright line. Federal government gets one side of the equation, the states get the other. So that is at least a coin toss at this time, I think. And it makes the practice more robust, if nothing else, I think, in this area.
I wonder if we could also just go down a slight sidetrack for a minute. You've been mentioned a couple of times the recent decision overturning the Chevron doctrine. And I wonder if we could talk about that just a little bit more, because, first to make sure that we're all on the same page about what that means, what Chevron was and how things have changed now, but also what are the practical implications, as far as we can tell, about the way decisions are going to be made and what the scope of the decisions will be.
Okay. So the Chevron decision goes back to the early 1980s, and it was a decision, again, with not a full court at the time, if I recall correctly, where the Supreme Court decided that when an agency using the Administrative Procedures Act, which applies to every federal agency, many states also have similar state administrative procedure acts. We have to worry about what agencies do as lawyers, because when a regulation is properly promulgated, it has the effect of law. And there are certain procedures like notice and comment in response to the comments, and creating a record that supports the decision and is not arbitrary and capricious, or in certain more limited cases is upheld by substantial evidence. And so it said, if the agency makes a decision, the starting point of analysis is the court will defer to that agency. because the agencies have expertise. And they certainly do, certainly compared to a court. FERC has, I don't know, thousands of employees that have some expertise in their areas. EPA, if we go back to environmental practice, has, probably 7 or 8 or more thousand employees with expertise in this. And when you become before a single federal trial court judge, that judge may or may not certainly have the resources that the agencies have. And so there was deference. Basically, that somewhat shifted the burden of proof for we as lawyers. So if the court's going to start saying we assume the agency's expertise is the starting point, it's the opportunity for the plaintiffs to bear the burden of proof to rebut that. What this did is it said, wait a minute, no, this is a separation horizontally between the executive and the legislative, and to some degree, even the judicial branches of the federal government. These basic issues have to, whether this is legally permissible, are not so much to be deferred to anymore. So the opinion here, again, was quite simple. It said, in a few words, Chevron is overruled. Now, here's the saving grace of that. This is the Administrative Procedure Act. It's a statute from the 1940s, if I recall correctly. And so to the same degree that it's overruled, Congress could amend the Administrative Procedures Act to say deference is required. And there's some bills pending in Congress now to do that. I don't know whether they'll move very far, but they're pending out there. The other thing is it did not necessarily, I'll back up a step. It did not throw out any of the decisions that were previously decided. Basically, you can't use Chevron as precedent going forward, but any cases decided prior to this decision in mid-2024, 2024, I'm sorry, any decisions are not jeopardized in any way. So those decisions are okay. If you wanted to reiterate them again, you'd have to come up with new support. It also mentions, but does not overrule, what's called Skidmore deference. And Skidmore deference, name of a different case, says that if an agency has particular expertise, the court can not necessarily have to defer, but can take that under advisement and might select to find that supportive and convincing. So I think it's still in play what this is going to do. There are a number of cases already involving energy and environment where people are raising major question doctrines or Chevron issues. And as I said, even within FERC, it's already been raised by one of the commissioners saying this really changes our room to operate and our discretion here. So, this is all making the practice in this area. And these cases are largely environmental and energy type cases that have gotten a predominant amount of these recent decisions affecting them. So, and some of them climate change also. So the court seems to be particularly scrutinizing some of those areas that we're talking about today.
Yeah, I wonder if, does in effect, does this recent action by the Supreme Court mean that ambiguous statutes can't be implemented?
Interesting question. Yeah, it's certainly, and there's a lot of ambiguous statutes because Congress, I think, this is part of the non-delegation doctrine. I probably should mention the ultra vires doctrine here just before we leave, but the non-delegation doctrine was a theory that sort of accompanied the Administrative Procedure Act in the 1940s, et cetera. And that was that Congress, as the first branch of government, their Article 1 of the Constitution, is sort of premier and has to agree to something. President has to sign it for it to have the effect of law, or in that statute, they have to have some clear principle of delegation. Interestingly enough, after sort of the mid-1940s, there was never another circuit court case except for one that ever found that something was not adequately delegated. That case also happened to be an environmental case, interestingly enough. I think it was the Whitman case. So, and then a lot of this is around our subject area for better or worse, but it affects all of government. The Supreme Court has always overturned it, and very few circuit courts have ever gone there. All of a sudden, though, there are several cases sort of hinting of that, maybe the better part of a decade ago, sort of forecasting that this might be coming. And so the question is there more of a delegation? Congress obviously can go back and amend any statute and make the delegation more specific now if they can get a majority and the president signs it. There's also the Congressional Review Authority, Congressional Review Act, where when a president leaves office, oftentimes if the Congress changes, they go back and undo period of recent months some of the regulations that were done. So there's more checks and balances than we used to have. But the other doctrine is also the ultra vires doctrine, and that's not gotten as much attention. But that is lurking in the two decisions right before the West Virginia major questions doctrine. And in that case, there was a moratorium during the pandemic on evictions because they didn't want to evict people who might be sick or might catch or spread disease. That moratorium was not done by our Centers for Disease Control, but it was extended by the Centers for Disease Control, basically on something that sounds like the precursor of the major questions doctrine. They said you don't have that authority, but that is more ultra vires, which means it's not so much that Congress didn't delegate it to you under the non-delegation doctrine. It's that you're outside your sort of lane of influence. So they said to the Centers for Disease Control in Atlanta, you're an expert in health, but not in the landlord-tenant issue. You can't do anything about evictions. Similarly, OSHA in the Department of Labor, which is our health inspector, as people went back to work after the pandemic, said any business with more than 100 people, I think I can more or less summarize this. They said you either have to get everybody vaccinated every week for workplace safety, or everybody's got to mask or have been or be tested at their own expense every week. So there were various options, and certain states and certain employers sued on that. That was also found to be sort of a precursor of major questions non-delegation, although not named that way per se. But that is ultra vires. They sort of said, yeah, you're in charge of workplace safety, but health is not workplace safety. It's more on the job, slip and fall, or keep your hands away from the dangerous machines. So there are a lot of interesting things that are really kind of brand new that nobody in our lifetimes of practice have ever seen used that are coming back and getting revitalized. And I think we're just sort of seeing the tip of the iceberg on this. These decisions in the court are often 6-3, so they're not at the current moment close to being changed, it looks like. So it's going to be an interesting decade or two here in the court.
There's no natural end to discussing this particular issue, but I think I'm going to have to behave myself and not ask you any more follow-up questions on that.
Okay.
But what I want to do before we wrap up is make sure we cover two issues. But one really has to do with the nature of electricity itself, and the other, of course, is to just dig in a little bit in terms of the book and what kind of coverage we have, what people can look for there. So first things first, you've been talking about natural gas a fair amount. We've talked about electricity. Natural gas domestically is by and large a pipeline system, and the electric system works on transmission lines. And I think a lot of people tend to think about transmission as just being another pipeline system, and that basically, what seems to work on the gas side might work on the electric side as well. So let's explore that a little bit. What's the fundamental nature of electricity? What makes it unique? If it's unique in some ways, what makes it comparable in other ways?
Okay. So again, natural gas, can kind of start with the basics here. The other major fuel sources are clearly commodities. So we'll just go to categorize them in law. They're products. They are goods. They're movable goods, tangible goods. You can hold and move coal or natural gas or oil. Electricity is a carrier form of energy. You cannot hold it, or at least you shouldn't try to hold it. And it is really you're really buying movement. So the states are very split as to whether electricity is a good or a service, or a product or a service. Why does that matter? In contract law, and of course we have a whole bunch of lawyers practicing with contracts with electricity and natural gas, there are about 12 significant differences between whether on decision rules, on offer acceptance, remedies, damages, as to whether the UCC applies to a good, if electricity is a good, as is natural gas, etc., or whether it's a service. Electricity is basically moving electrons. No additional electrons are ever created. It's the electrons in the copper wires, in our lines, and our walls. When they get an electromagnetic force around them, they start to vibrate. The outer electron in that copper or that aluminum wire starts to oscillate 60 times a second from molecule to molecule back and forth. By the electromagnetic force doing that. Question is that movement a service, or is that movement a good? And the states are totally split. 3 of the states in different courts have actually, in some cases, held it to be a good, some cases held it to be a service for tort law simultaneously. In tort law, it makes a difference whether you get strict product liability when somebody gets injured by electricity for goods or products as opposed to services. It makes a difference in bankruptcy law as to whether you get priority for having sold a product or good. It makes a difference in antitrust law. So in a lot of areas of law, that issue is sort of there. But electricity is unique because it moves. Electricity cannot be stored as electricity. So we think of electricity storage, and that's one of the big changes also technologically, is now we have batteries that have significant storage issues, storage capabilities. There also are issues, I touch on that briefly in the book, the batteries and some of the new technologies, even some of the renewable technologies use much more critical minerals and rare earth materials. Those are generally not sourced from the U.S., although the Biden administration legislation is trying to give incentives for more U.S. manufacture of chips and everything else, including some of these products, and higher tax incentives for that. But most of those things are sourced in foreign countries, some of which we don't have the best foreign relations with. And most of those rare earth minerals and critical minerals, rare earth materials, I guess would be a better way to say it, between about 60 and 90% of each of those dozen key minerals are processed or made into usable products in China. And we know right now, obviously, all the news that we get, that we're still working through our relationship with China and that. So electricity is very different in those senses. It is not stored as electricity. You have to lose power and store it as chemical energy in batteries, or you have to pump the water back out of a river up to a pump storage facility at greater height. And then when you want to have extra power, let it run back down through the turbine and then push it back up. Lifting water with electric power is a very intensive process. So we do it that way, but that's kinetic energy. That's not really storing electricity. It's storing water at height and using gravity. Flywheels, again, use movement. Electricity cannot be stored as electricity. You have to use it within a second or two, or the whole system is in trouble, and the electricity, if there's a surplus, gets wasted as waste heat. So it's a very different commodity, I guess, to answer your question on that. It's different than gas. And as I said, the original Federal Power Act in 1935 segregated state versus federal power, which it did not do in 1938 in the Natural Gas Act. So it's a very different nature of practice. It's a different material. It's a different thing.
So on the gas side, basically the whole system is storage, right? You've got reservoirs, but you also have pipes, and the pipes can hold a certain amount of gas. And storage is a big challenge with electricity, isn't it? There's probably a lot to say about what the implications are of that. I think you've touched on some of them. I want to give you a chance before we wrap up to talk just briefly about the book itself, about the organization of the book, what you're trying to accomplish with it, and how it might be useful to people.
This book is basically trying to do something that is not time sensitive. So I guess one of your questions is, well, does this change if there's a change in presidential administrations? Let me just talk about why I think it has some legs to it in time, and then I'll try to tell you what its main sections are and what they try to do. So let's assume there's a Democratic victory in the next election here, at whatever time somebody's listening to this. If the Democrats, even if as long as the Democrats hold some but not all of the houses of Congress, the Trump administration tax law changes and other changes sunset at the end of 2025. But the stuff that really affects electric power is involved with the Inflation Reduction Act and the Infrastructure Acts in 2022 and 2021, respectively. And those don't sunset until 2032. So that's two more presidential administrations. And because of some ability to start construction and to be grandfathered, it's probably more like a full decade. So that's into three more presidential administrations from where we're talking now, right before the 2024 elections. And secondly, if the Republicans win, there are many states that have very good renewable energy of various kinds, whether it's run-of-river hydro, assuming that passes environmental concerns, or solar, or wind, or are choosing to incentivize it. 60% of our states, 60%, have renewable energy credits that are incentivizing waste fuel and renewable energy. Approximately 40% of our states give net metering credits, which can be quite remunerative to different renewable sources. So a lot of states are promoting this, and that those state-level incentives survive anyway. The final thing I'll say, and then let me just tell you briefly about the book, is let's assume that, we've got a split Congress when we're talking right now in mid-2024. Let's assume that the Democrats were to win control of both houses and a control of the presidency, which is one possibility out there. In that case, a lot of the talk is about the Green New Deal. This leads me into what's in the book. The final section of the book, and then I'll tell you about the first 3 sections. The book is organized in 16 chapters. Each is self-contained. Each says, here's a problem, here's an issue, here's how the practice in environment, energy, land use, climate is changing. Here are workarounds. Here are particular states where you have advantages. Here are maps of those states. In every case, I'm trying to work in workarounds, saying, okay, there's going to be a stopper here or a long multi-year delay. Try doing this, try doing that. Here's some helpful case law on either side of the issue, etc. Final 3 chapters talk about things that are not on the radar screen. One of those is the Green New Deal. I try to go through issues with the Green New Deal, how some of it may not work, how some of it will work. And when I say it may not work, it may be legally stricken. So I sort of walk through that as one of the major agenda items that has not yet emerged, although it has been proposed several times. I also look at a new chemical, particularly methane, and how that's going to change the type of energy we can develop and why that is more environmentally damaging by a factor of 500% than originally assumed, based on some recent research out of Princeton and Harvard, et cetera. And so I'm trying to look at some new stress on the grid. As you mentioned, the grid is quite an amazing machine that moves our power around. So the book organized is basically like this. The first few chapters talk about why electricity is totally different in response to your former question. What's so different about electricity? Why it's so unique, why it's technologically different, legally treated differently, and how the new effort to try to decarbonize and cut global warming is changing the technology, a little bit influencing the law and the dynamics of this, and how the administration is responding and what has held up to judicial scrutiny and what has not. And we've mentioned the West Virginia case striking one of the major CO2 reduction statutes in this country. The second section of the book is the major one. It takes each level of government and looks at a whole range of different regulation. You mentioned at the federal level, at the state level, at the local level, to get cited both to technology as well as the transmission ability to move it and the battery storage to store it, and sort of says, okay, here's the multi-level constellation that you have to navigate through. Here's how you do each one. Here are the likely barriers you're going to hit. These aren't going to change either way, at least for, let's call it, roughly 3 presidential administrations, because these statutes are in law and are basically grandfathered significantly and don't sunset until the 2030s. And so that's really the meat of the book, and the bulk of the book is the middle section kind of going through where's the federal law at, where's the state law at, how's this changing, why are 700 cities in 49 states now opposing, as we mentioned earlier, large solar and large wind. What's the ability to have that sustained? What's the ability to work around it? So we've always known that people have not enjoyed living near electric power plants, mainly fossil fuels. Now there's documented at Columbia University, they have a database of, I think, about 350 local and state ordinances and cases blocking new renewable and solar. I've also cited in the book another database coming out of Texas with twice that many, more than 700 of these, and again in 49 states. So the desire, the resistance, whether it's transmission lines or more generating power in large scale, hasn't ceased, even though I think most people think of solar and wind maybe as not quite as environmentally questionable as some of the traditional power. So that's the second of the book. I think that's the meat of the book. I also have maps in it that sort of say where are you going to get the best cost-effective bang for the new renewable solar and wind, which for the last 10 years has started to dominate even the natural gas and other fossil new generation. And then the third section of the book is something for lawyers, clients, really. It's sort of saying, how does the business model need to change to accommodate how's your client going to be thinking about this? Your client who thinks about, is this a cost-effective project? How much hassle is it to go forward with this? And so that looks at both how the business model changes with the new technologies we've talked about and how the business model is going to be influenced by the new changes in law that we've talked about. And that's really I think, for lawyers to show their clients or share with their clients or get their clients to read as a precursor to them thinking about their next move. So that's kind of how the book is organized.
Well, Steve Ferry, I've known you a long time, and we've talked about these issues for years. And just want to tell you, just continues to be a great pleasure to talk to you. You blow me away. I really appreciate what you bring to the subject and bring to the field. The name of the book is Powering the Future, A Lawyer's Guide to Clean Energy by Stephen Ferry. It's just issued by the American Bar Association, and so I encourage you to look at it. I think it's going to be a useful book, not only for practitioners, but also for educators. I think it speaks to these subjects in a very clear and understandable way. So thank you very much, Steve, for this book and for spending time talking with me today. And thank you to those of you who have been listening in.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/Envira. Please check where you found us for future episodes. Thank you for listening.